Good morning, this is your Kelso Report for Wednesday, January 25th, and I'm your host, Clark Kelso. We begin today with a Ninth Circuit case involving the law of bankruptcy. Now, the model for resolving corporate bankruptcies that are related to asbestos claims was really set a few decades ago almost now, and it involves creating out of corporate assets and insurance payments a large trust fund, and then issuing broad injunctions to channel all asbestos-related claims for that company to the trust fund. One of the important questions in this type of bankruptcy is whether it is insurance neutral, in the sense that the bankruptcy plan does not alter, impair, or change the rights of any insurance carrier. If a plan is insurance neutral, that keeps the insurance companies largely out of the bankruptcy plan process itself, where they might otherwise effectively veto any plan. In the matter of Thorpe Insulation, the Ninth Circuit faced a complex and difficult appeal because the plan had been confirmed by the district court on the premise that it was insurance neutral, and a stay of the plan had been denied. Yet over a year later, the Ninth Circuit panel concluded that the plan actually was not insurance neutral. Well, that raised difficult questions of whether the appeal was moot, since the plan already was being implemented, whether the insurance companies had appellate standing even, and what sort of relief might be crafted. Ultimately, the Ninth Circuit held that a bankruptcy court had enough equitable flexibility to craft some type of relief, even if it could not entirely start over. So it remanded to the bankruptcy court with directions to permit the insurers to file objections to the plan and then to conduct further proceedings to see where that might lead. Now we have four cases from the California Courts of Appeal to discuss. The first involves labor law. In a lot of cases involving overtime pay, this is another one of them. This time, we take a look at the application of the commissioned employees exception. Now, as you know, under Section 510 of California's Labor Code, employers are required to pay overtime wages for any work in excess of 8 hours in one day, 40 hours in one work week, and the first 8 hours worked on the 7th day of work in any work week, except that certain types of employees are exempt from this requirement. One such exemption is for employees who are classified as commissioned employees. And under this exemption, employers are not required to pay overtime wages to employees whose earnings exceed 1 1/2 times the minimum wage if more than half of that employee's compensation represents commissions. Well, in Muldrow versus Surex Solutions Corporation, the 4th District affirmed the trial court's conclusion that the employee plaintiffs, who worked as employment recruiters on a commission basis, were subject to the commissioned employees exemption and therefore were not entitled to overtime pay. Although the basis of the commissions in this case was certainly much more complex than commissions paid to, say, car salesmen, it was still clear that the commission to these employees, the compensation to these employees rather, was based on a percentage of revenues received by the employer for sales and contracts closed by each salesman. That was enough to convince the court that these were commissioned employees. Next, we have a Public Records Act case. The public's interest in knowing what government and government employees are up to sometimes runs right into conflict with the rights of individual government employees to maintain some degree of privacy about their own lives. How to strike that balance was the issue before the 2nd District in Markin versus Santa Monica Malibu Unified School District, where the 2nd District had to decide whether the Public Records Act required disclosure of certain information in a high school teacher's personnel file. Several years ago, the teacher had been accused by a female student of sexual harassment. After a month-long investigation, the district had concluded that some of the allegations were true and others were false. And while the district permitted the teacher back into the classroom, he received a written reprimand. Several years later, a parent who had heard rumors of the problem filed a demand for disclosure of the letter of reprimand and any other relevant documents under the Public Records Act. The school district had decided to release the records, but the teacher then filed a so-called reverse Public Records Act action, seeking a preliminary injunction to block the release. The trial court first issued a temporary restraining order, but then, after a hearing, decided not to issue a preliminary injunction. It reasoned that, although the teacher had a legitimate interest in the confidentiality of his personnel file, the public's interest in disclosure was stronger, since the harassment complaint against the teacher was apparently well-founded and substantial in nature. The appellate court affirmed, noting that the employee occupies a position of trust and responsibility as a classroom teacher, and the public has a legitimate interest in knowing whether and how the district enforces its sexual harassment policy. Our next case involves an aspect of criminal procedure and collateral estoppel. Sometimes what appears to be a convenient shortcut may turn out to be a very dark and dangerous alley. And that's what happened to the prosecutor in People v. Quarterman. It all seemed so simple. The defendant, already on probation, allegedly pawned a camera and camera accessories with knowledge that the items were stolen. She was charged with receiving stolen property in violation of her probation. The prosecutor asked for a joint preliminary hearing and probation violation hearing. Sounds good so far, but then the prosecutor put on only one witness at the hearing, a police officer who testified to various hearsay statements as permitted by Proposition 115. The court held the defendant to answer on the criminal charge, but held that the probation violation could not be sustained because there was no admissible evidence showing the property was stolen. The Prop 115 hearsay was sufficient for the preliminary hearing, but not for the probation violation. The prosecutor then tried to cure his mistake by simply asking a different judge for another probation violation hearing, which surprisingly was granted. And the second judge found a violation based on presentation of additional evidence. Well, hold on, said the First District Court of Appeal. It was then too late. The doctrine of collateral estoppel applied to prevent the prosecution from relitigating the probation violation. Prosecution had its shot at the first hearing, and you don't get to take multiple shots. When you lose, you lose. You don't get to play a mulligan. Finally, we have a habeas corpus case and a bit of procedure. Convicted murderer Henry Bratton should have been released on parole in 2008, but Governor Schwarzenegger unlawfully reversed a favorable parole determination which had been made by the Board of Parole Hearings. Ultimately, Bratton was released on parole, but he had remained in prison for 2 years while his challenges to Schwarzenegger's decision were litigated. He sought to have those additional years in prison applied as a credit against his parole period. And to achieve that result, he filed a petition for habeas corpus, essentially seeking declaratory relief. But he skipped a step. He had filed his habeas petition without bothering to ask the Board of Parole Hearings how it would decide the issue. So the 6th District in re Henry R. Bratton dismissed the petition for failure to exhaust administrative remedies and sent Mr. Bratton back to the Board of Parole Hearings so it could decide in the first instance whether to credit his additional time in prison. And that's it for today's Kelso Report. Have a great day in the law.